Recording in progress.
Before I say anything, I just want to make everyone aware of the fact that this meeting is being recorded. We do have a recording, a court reporter at her site, taking everything down so that the record is complete and will be available for people to view. And again, good morning to all of you. My name is Joe Fiordaliso, and I am the president of the New Jersey Board of Public Utilities and the presiding commissioner for today's proceeding. Today, we are here for the oral argument regarding the petition filed by Ocean Wind LLC for authorization to obtain easements across Green Acres restricted properties and consents needed for certain environmental permits in and with respect to the city of Ocean City are reasonably necessary for the construction or operation of Ocean Wind 1 qualified offshore wind project, docket number QO22020041 NJSA 48:3-87. Grants the board the authority to make a determination on this petition. Since we have all of the commissioners of the Board of Public Utilities on hand today, this proceeding is a public meeting of the New Jersey Board of Public Utilities. Adequate notice of this meeting has been provided as required by the Open Public Meetings Act, set forth in NJSA 10:4-6. To date, we have the following on the docket. On February 3, 2022, Ocean Wind LLC filed the petition seeking determination that certain easements and consents are reasonably necessary for the construction of Ocean Wind project. This petition was accompanied by testimony from Pillard Patterson, Jason Kelwa, and Madeline Urbish. The board issued an order retaining the petition and assigning myself as presiding officer on February 23. I set the initial procedural schedule and requested supplemental information from the petitioner in an order on March 1st. On March 15th, Ocean Wind submitted answers to the request for supplemental information. On March 22nd, I issued an order naming Ocean City as a necessary party and updating the procedural schedule. On April 27, Ocean City filed a response to Ocean Wind's March 15 response. Also, on April 27, Ray Council filed testimony from Maximilian Chang. On April 29, Ocean Wind filed an amended petition revising the acreage impact upon or under the proposed green energy diversion downward. On May 11, Ocean Wind filed a rebuttal testimony to the April 29 response from Ocean City. Public hearing was held on May 19, and the board received written comments before the deadline of June 2nd. On June 16th, Ocean Wind filed a reply to Rate Council's comments. This petition represents the first request for authorization under NJSA 48:3-87.1 because the petition has the potential to affect the property interests of Ocean City. The board takes this responsibility very seriously and is committed to providing a fair and transparent process. With us today are representatives from the parties, Ocean Wind, Ocean City, and the Division of Rate Counsel. Each of the parties will have the opportunity to present their argument, starting with the petitioner, Ocean Wind, followed by Ocean City, and then Rate Counsel. The parties have indicated that each argument will take approximately 15 minutes. After the initial argument, all parties will have the opportunity for a short rebuttal. As noted, the commissioners are present today and may ask questions at the end of the presentations. I want to remind the parties and the public that arguments in this proceeding should be limited to the matter at hand, whether the easements and consents sought by Ocean Wind LLC are reasonably necessary for the construction or operation of the project. Not at issue today, let me underline that, not at issue today, are the desirability of offshore wind, the location of the project in the ocean, or any environmental aspects, positive or negative, of the Ocean Wind project as a whole, except as they relate to the easements and consents sought under the petition. I will ask that when a party is speaking, please ensure your camera is on you and you are unmuted. When not speaking, please turn your video and microphone off. On a personal note, I had hoped that we would be doing this procedure in person, but at the request of one of the parties, we are doing it, as you can see, virtually. And I am sure we will get all of the information that we need in order to make a fair determination as we go along. With that, I will invite Ocean Wind to make their statement. Ocean Wind?
Thank you, President Fiordaliso. And I just want to check, can everyone hear me okay? I always like to
Very
ask
well,
that.
yes.
Thank you. And thank you, President Fiordaliso, Commissioners Holden, Solomon, Chivakula, and Gordon. My name is Gregory Eisenstark. I'm with the law firm of Cozen O'Connor, and we represent the petitioner, Ocean Wind LLC, in this filing. I'd just like to start briefly by thanking the board for this opportunity to present some additional detail about the filing, put some issues into context, and explain in some more detail what exactly it is that Ocean Wind is asking the board to do here. I think everyone here is aware that this filing concerns the Ocean Wind 1 qualified offshore wind project. That will be the first offshore wind project constructed off the coast of New Jersey. It's an 1,100 megawatt offshore wind project. And why are we here today before the board? Why did Ocean Wind file this petition back in February of this year? Well, as everyone knows, you have to get the generation that's being generated 15 miles or more out in the Atlantic Ocean to the shore and to interconnect with the existing electric bulk power system. All the load, the customers that are going to use the electricity are located on land. They're, of course, not located out in the ocean. So any offshore wind project, including this one, Ocean Wind 1, needs to construct cables from the ocean and make landfall on the land and then across a portion of the land and interconnect with the existing bulk power system. For this particular project, for Ocean Wind 1, the project examined a number of what we call points of interconnection. That's a POI, or where the project will interconnect with the existing electric grid. Ultimately, after a fair amount of evaluation, it was determined that there are essentially two viable points of interconnection for Ocean Wind 1. One is in Lacey Township in Ocean County, and the other is in Upper Township in Cape May County. Both will be used for this project. The point of interconnection we're talking about here, of course, today is the southern one, the one in Cape May County in Upper Township. And what this matter is about is Ocean Wind's attempts to site the onshore cable from where it makes landfall, where the under ocean cable meets land, to the point of interconnection in Upper Township. Basically, as the board is aware, the board approved Ocean Wind 1 just a little over 3 years ago. It was in June of 2019. Hard to believe that 3 years have now passed since that initial approval was granted. Shortly after that initial approval was granted by the board, Ocean Wind began discussions with Ocean City and its representatives. The discussions were extensive. The project explained what it needed as far as locating the cable, property rights, environmental permitting consents. And those discussions went on for some time. Unfortunately, as we sit here today, the project was unable to get the necessary property rights or the necessary municipal consents from Ocean City, which necessitated this filing. As I think all the members of the board gathered here today are aware, in 2021, the legislature saw fit to amend the Offshore Wind Economic Development Act, OWEDA, to allow the board, to give the board some additional jurisdiction to address situations like the one that we're faced with here today, and that is the siting of the onshore portion of a qualified offshore wind project. I think the legislature acted because while OWEDA was a very progressive and forward-thinking piece of legislation back in 2010 when it was enacted, it didn't address the onshore portion of what needs to be constructed for a qualified offshore wind project. And unlike public utilities, electric utilities, gas utilities, water and sewer utilities, which have some statutory rights to occupy public rights of way, to seek condemnation for property rights, and to override some municipal approvals, offshore wind projects didn't have any of that before these recent amendments, the 2021 amendments. So those amendments, I believe, and Ocean Wind believes, were necessary to address the type of situation we have here and to allow the siting of offshore wind projects and the onshore portion of it. So basically, as President Fiordaliso discussed briefly earlier, this petition was filed under those recent amendments. There's NJSA 48:3-87.1F, subsections 2 and 3. And essentially, what the filing seeks is, there's a lot of paper in the record in this thing. There's extensive testimony, rebuttal testimony, and exhibits. But the relief that Ocean Wind is seeking is actually fairly simple. There are really just 2 or 3 issues that we're asking the board to get involved with and approve here. The first issue is the approval of the acquisition of 2 easements for the underground construction of the electric cable. One of those easements is at the beach fall at 35th Street in Ocean City. The second of those easements is at the point where the underground line will cross a bay crossing at what's known as Peck's Bay at Crookshorn Creek, at the border of where Ocean City meets on the other side of the bay. It becomes Upper Township. Those are the 2 easements the project has asked the board to approve. The total acreage of those easements in total is 0.647 acres, so just a little bit more than half an acre. Each of the easements is approximately 30 feet wide, so they're not very wide, and the easements are simply necessary for the installation of the underground cables. In conjunction with that, both of the parcels over which Ocean Wind is seeking easements are encumbered by Green Acres restrictions. Green Acres restrictions, and I won't go into a great deal of detail about what the Green Acres program is, but suffice it to say that the state Green Acres program provided funding and for the acquisition of certain property, and that property is generally preserved as parkland unless an application is approved by the NJDEP to divert that. And then if they do approve a diversion, there are various things that the entity that seeks the diversion has to do in order for the DEP to approve the diversion of green acres, one of which is obviously to acquire an easement and to pay the property owner the fair value of the easement. The second is to pay into a state green acres fund, a sufficient fund that would allow the acquisition of 3 times the acreage to be diverted to be set aside for new green acres property. So that's the first thing, the acquisition of these 2 easements. The second thing that the project Ocean Wind is asking the board to approve is to essentially override or preempt the municipal consents that are required, would otherwise be required from Ocean City for the NJDEP permits. And it's in the record of our filing here. We discuss in our pre-file testimony, we list all of the DEP permits that the project will require before it can begin construction. The way the DEP permitting process works, the property owner must consent to the application and the issuance of for the DEP to go through the permitting process. In this case, Ocean City is the property owner for the 2 easement areas and the rest of the underground cable route for the project. So absent the recent amendments to OEDA, Ocean City would have had to consent to the DEP permit applications. As I alluded to earlier, as of now, Ocean City has not consented to those DEP permit applications. So we are asking the board to step into the municipality's place and allow the DEP permit applications to be processed and go forward, which hopefully at the end of the day will result in the DEP issuing the permits that are required for the project. I just want to touch on a couple of other things just in detail. And most of this, I'm not going to obviously cover everything that's in the petition and the direct and rebuttal testimony we filed, because we'd be here all day if I tried to do that. I just want to make it clear that Ocean Wind complied with the statutory requirements. As I mentioned earlier, we've been discussing the needs that we have within Ocean City for, literally close to 3 years now. On August 11th of last year, the project sent a formal letter to Ocean City, which sometimes is referred to as the 90-day letter, specifically outlining in writing what we needed as far as easements, property rights, and permit consents. At some point after that, Ocean Wind also had an appraisal done for the 2 easements that it needs. It sent a formal offer letter to Ocean City offering to acquire those easements at 10 times the appraised value. That offer has not been accepted or even formally responded to, and that resulted in the petition being filed. I just want to highlight a couple of other things. As I said earlier, I'll just briefly describe the route of the underground cable. And let me pause for a second here, because I want to emphasize all of the electric cable at issue in this filing will be constructed underground. None of it will be overhead. It will come ashore at 35th Street at the beach. And where it passes under the beach, it will be installed by what's known as horizontal directional drilling, which is an underground drilling process. The line as it passes under the beach will be very deep. In parts, the line will be 60 feet below the surface of the beach, to give you an idea of how deep this line will be. It will then go up, and it will then pass under the beach and come up in the public road right of way on 35th Street. From that portion within Ocean City, the entire line will be, most of the rest of the line will be conducted essentially in conduits, in duct banks, much like any other existing electric utility underground line, gas line, water line, telecommunication lines that are already in place in Ocean City and in most other municipalities in the state. The construction will be no different. It will be constructed underground within vaults, and it will be constructed much the way any other facility will be constructed. The only other place that it won't be constructed within the public road right away, as I mentioned earlier, is at the Bay Crossing on Roosevelt Boulevard, where it crosses at Crookhorn Creek. At that crossing, again, there is the second easement that's required. And at that point, because we have to cross underneath the land and underneath essentially the bay or the creek, horizontal directional drilling will be used again. And that takes us, that's the end of the portion of the line that's at issue here in Ocean City. The line will then come up on the other side of the bay. It will again be constructed in public road right of way through up the rest of the way to Upper Township, and it will interconnect with a new substation that will be built in Upper Township basically at the location of Atlantic City Electric's BL England substation. It will be constructed on a nearby parcel, and it will interconnect with the Atlantic City Electric grid at that point. So again, all of the portions within Ocean City will be underground. Once construction is completed, the lines won't be visible. You won't see them. You won't hear them. You really won't know that they're there. Let me pause for a second and just check my notes. Let me just speak for a few moments on the statutory standard of review. And I think President Fioraliso mentioned this in his opening remarks. The standard is for the easements, whether the requested easement, right of way, or other property, real property interest are reasonably necessary for the construction or operation of the qualified offshore wind project. I just want to take a second, and it's the same standard that applies to the environmental permit consents as well. In other contexts, when the board has had applications or petitions from public utilities to override municipal zoning authority, the board has had chance to comment on what the reasonably necessary standard is. And I just want to make it clear here, the reasonable necessity standard doesn't mean it's absolutely necessary. It doesn't mean it's the only alternative. It doesn't even mean it's the best alternative. It just means that the project evaluated different alternatives, and the alternative it is proposed is a reasonable one. It doesn't have to be the best one. It doesn't have to be the lowest cost one. One other point that I'd like to make is, what this filing is not about. And I think it's important to emphasize this, and I may get into this a bit in rebuttal, quite frankly, depending on what comments Rate Counsel makes. But based on their testimony, which we've responded to in rebuttal testimony, Rate Counsel has raised some alleged concerns about cost of the project. And I just want to make it clear, this filing really isn't about what this underground portion of the project will cost. And that's because this isn't a public utility project. This is a qualified offshore wind project. The project, as the board is well aware, was competitively bid. Ocean Wind submitted proposed OREC prices. Those OREC prices were determined 3 years ago in the board's 2019 order, and they won't be modified based on anything that happens in this filing or with this portion of the project. The risk of cost overruns, or conversely, the benefit of cost underruns from this portion of the project, is entirely on Ocean Wind. It will not impact the costs that ratepayers pay through OREC prices one way or another. There was some confusion in some of the comments that were filed about the transmission system upgrade cost sharing mechanism. That is one of the limited instances in which OREC prices can be adjusted. I just want to make it clear here today, and we have testimony in the record. Matthew Kaplan's rebuttal testimony explains this in some detail, but the transmission system upgrade cost sharing mechanism does not apply to the facilities we're talking about here. The TSUC only applies to essentially PJM directed transmission system bulk system upgrade costs. So when the project has to apply to interconnect and enter into interconnection agreements with, in this instance, Atlantic City Electric for this interconnection, JCP&L for the one in Lacey Township, PJM identifies costs that will be necessary to essentially upgrade the bulk power system to allow the interconnection and the interjection of this amount of electric generation capacity into the system. Those are the costs that are subject to the TSUC sharing mechanism. Though the cost to run the lines from the turbines out in the ocean to the beach or to landfall, and the underground portion from the landfall to the new substation, is not within the TSUC. So that is why this is a little bit different than a utility project. Often in utility infrastructure projects, when a utility comes in, the board is interested in how much it's going to cost, because the board knows that eventually the utility is going to file a base rate case and seek to include all of the capital costs in its rate base. Here, that's not the case. Ocean Wind isn't a utility. It's not regulated, its rates aren't regulated by the board. And at least for the facilities we're talking about here in this filing, they will have no impact on the amount that customers pay. That has already been determined in the board's 2019 order. It's not up for reconsideration here or really anywhere else. So I just wanted to make that point clear. One last point, and I know I've been talking for a while and I don't want to overstay my welcome here and leave time for others to comment. I just want to make it clear that from Ocean Wind's perspective, we've clearly satisfied the statutory standard. We filed a verified petition. We filed 3 pieces of direct testimony with supporting exhibits, explaining exactly what we need, explaining the outreach we've done to Ocean City prior to filing the petition, explaining what the construction will be like, explaining what environmental permits we need, and explaining in detail what the 2 easements are. From our perspective, our filing meets the statutory standard and is unrebutted. The only party to file testimony in response to the direct testimony of the petitioner was Rate Counsel. Rate Counsel raised a number of issues. I'm not going to put words in Rate Counsel's mouth. I don't think Rate Counsel is opposing the project. They raised what I consider a number of concerns. I think we clearly addressed them all in the rebuttal testimony and have adequately explained why those concerns are not valid and do not deter from the filing the company has made and the relief that we're requested. So again, with that, I'm going to stop at this point and reserve a few minutes in case I do need rebuttal. I'd be happy to answer any questions that President Fiordaliso or any of the commissioners may have. And at this point, that would conclude my direct presentation. Thank you.
Very good. Thank you very much. We're going to save questions until the end of the presentations and so on. And if anyone has them at that point, I thank you for your statement. I now invite Ocean City to make their statement.
Thank you, President Fiordaliso. Good morning to you and to the commissioners. I'm here on behalf of Ocean City, and Mayor Jay Gillian and Business Administrator George Savastano are with me this morning. Thank you for the opportunity to provide closing argument in this matter. Ocean City will address 5 points. Ocean City questions the authority of the BPU to grant the petition that Ocean Wind has filed in this matter. Ocean City urges the BPU to refer this matter to the Office of Administrative Law. Ocean City believes that the board should require Ocean Wind to disclose costs of alternative routes prior to making a decision in this matter. And Ocean City believes that the board should wait for the issuance of a final environmental impact statement prior to making a decision on the petition. The city respectfully questions the authority of the BPU to consider Ocean Wind's petition seeking authority to obtain an easement over the city's fragile beach and wetlands and its environmental permit consents. The New Jersey Administrative Code, section 7:36-26.8 permits local government units to initiate an application for diversion of lands on its recreation and open space inventory. The hastily adopted NJSA 483-87.1F, upon which Ocean Wind relies and pursuant to which the BPU is now proceeding, purports to broadly preempt and supersede all other state laws, rules, and regulations. It strips elected municipal officials of the power to decide whether Ocean Wind, a private corporation, may take municipal property rights within Ocean City, in complete disregard of the will of the governing body and its constituents. NJSA 48:3-87.1 has not yet been tested in the courts. It remains to be seen whether it will survive judicial scrutiny. The board is likely familiar with the admonition in the New Jersey State Constitution of 1947 that, quote, any law concerning municipal corporations formed for local government or concerning counties shall be liberally construed in their favor. Article 4, Section 7, Paragraph 11. the novelty of NJSA 48:3-87.1F, coupled with the cited language from the New Jersey Constitution, should be reason enough for the board to refer Ocean Wind's petition to the Office of Administrative Law as a contested case under NJSA 52:14F-1 et sec for hearing and disposition. Additionally, there can be no doubt that this is a contested case under the Administrative Procedure Act and under NJAC 1:1-2.1. The case law confirms this. First, this hearing is required by statute. Second, the hearing will result in an adjudication concerning rights, duties, obligations, privileges, benefits, or other legal relations. And third, the hearing involves specific parties rather than a large segment of the public. These three factors are enunciated in Board of Education of the Upper Freehold Regional School District versus State Health Benefits Commission, 314 NJ Super 486, Appellate Division, 1998. Further, in this matter, there is a disputed issue of fact. Ocean Wind argues that the Great Egg Harbor route would cross under two historic bridges with low clearance, making construction of this project using that route significantly challenging. Ocean City has taken the position that neither of the bridges spanning the Great Egg Harbor route is historic, nor has low clearance. This issue of fact alone is reason for the board to refer this matter to the Office of Administrative Law, and Ocean City urges the board to make that referral. NJSA 48:3-87.1F treats Ocean Wind as if it were a public utility by giving it the power of eminent domain, modified by the requirement of the BPU, an agency charged with the oversight of regulated utilities, finds its seizure of property rights from the City of Ocean City and soon to come County of Cape May to be reasonably necessary. Yet, according to Ocean Wind, the statute excuses Ocean Wind from the obligations of a public utility to disclose the costs of its preferred route or chosen path, ostensibly because the cost of construction would be borne by Ocean Wind. The cost of construction is absolutely relevant to the question of whether Ocean Wind's preferred route is reasonably necessary. Realistically, each and every criterion constraint considered in the evaluation of the point of interconnection and preferred route could be mitigated if cost were no issue. It appears that Ocean Wind is promoting the most economically expedient route. This is a self-serving approach at the cost of Ocean City. Until and unless Ocean Wind discloses the cost of each of the alternate routes, the board cannot find that the easements and consents which Ocean Wind seeks are reasonably necessary. As Ocean City has previously argued, Ocean Wind could dispense with its efforts to wrest property rights from Ocean City against the will of its governing body by pursuing the Great Egg Harbor route. The Great Egg Harbor Inlet is sufficiently wide to accommodate this route without impacting the U.S. Army Corps of Engineers Borough area, which is solely on the Ocean City shoreline. Restriction of other vessels during construction in this wide inlet does not equate to a closure of the inlet. Navigation would continue during the temporary period of construction, as it did during the construction of the Ocean City Longport Bridge in and around 2002. By contrast, the preferred route would traverse a much, much narrower but equally heavily traveled Peck's Bay at Crookhorn Creek. The reduced distance of the preferred route likely translates into lower costs for Ocean Wind. However, it requires disturbance of the barrier islands, beach, and wetlands. This disturbance would be eliminated by using the Great Egg Harbor route. Going through Ocean City is not reasonably necessary. Disturbance of shellfish habitat in the Great Egg Harbor Inlet, another factor which disqualified the Great Egg Harbor route, can be mitigated with a monetary contribution to the NJDEP's Fund for Shellfish Habitat Mitigation and Restoration pursuant to NJAC 7:7-17.1 et sec. This is another strictly monetary issue. It is surprising to Ocean City that Ocean Wind argued that the Great Egg Harbor route would cross under two historic bridges with low clearance. Both have high clearances, 65 and 55 feet respectively. Neither bridge would be an actual obstacle to construction. The overwhelming benefit of utilizing the Great Egg Harbor route is the utter lack of disturbance to the citizenry of Ocean City. The city's pristine beach and wetlands would not be disturbed. The streets would not be excavated. Ocean City would still bear the aesthetic effects of this project and whatever consequences they may bring. However, the island would not be defaced and the activities of the people on the island would not be interrupted. It seems clear that the Great Egg Harbor route was eliminated due to economic reasons. It is a more difficult route, perhaps a more expensive route, but surely not impossible to implement. In its June 16, 2022 response to written comments, Ocean Wind explains that it eliminated the Great Egg Harbor route for a myriad of reasons, many of which were related to the characteristics of the inlet, which I've already addressed. Ocean Wind appears to have overcome similar obstacles in its Oyster Creek proposals to install cable crossing Barnegat Inlet and/or Barnegat Bay. For that project, shallow areas will be dealt with through dredging. Target burial depths will be determined based on an assessment of the seabed conditions, seabed mobility, and the risk of interaction with external hazards such as fishing gear and vessel anchors, while also considering other factors such as maintained navigational channels and thermal conductivity. Many of those issues were cited in the decision to eliminate the Great Egg Harbor route as a possible route. Ocean Wind will develop a cable burial risk assessment for the Oyster Creek project. And in the event cables cannot achieve proper burial depths, or if cables would cross existing infrastructure, Ocean Wind has options, including rock placement, concrete mattress placement, frond mattress placement, rock bags, or number five, seabed spacers. These solutions are proposed for the Oyster Creek site, according to BOEM's draft environmental impact statement, pages 2-13 to 14. They have not been cited as reasons to reject Ocean City's preferred route in the Oyster Creek substation. Ocean Wind claims that the Great Egg Harbor route would be 5.8 miles within a designated shellfish habitat. It appears that the distance from the edge of Island Beach State Park to Oyster Creek is longer than 5.8 miles. And as for the environmental characteristics of the seabed to be traversed to reach the Oyster Bay substation, according to the BOEM draft environmental impact statement, Barnegat Bay is an estuary of national importance and part of the National Estuarine Research Reserve System. 4 artificial reefs are mapped offshore, adjacent to the Oyster Creek offshore export cable corridor. 4 shellfish leases, 37 acres, and 1 research lease occur in the vicinity of Oyster Creek, with the primary shellfish grow-out of oysters and hard clams. The proposed offshore export cable to the southernmost landfill option for Oyster Creek traverses an aquaculture lease area on the west side of Barnegat Bay. Barnegat Bay supports invertebrate species such as hard clams, soft clams, blue mussels, bay scallops, and eastern oyster. Ocean Wind evidently believes it can address all of the challenges these conditions present in the Oyster Creek landfall proposals, but would have you believe that the similar challenges in the Great Egg Harbor route are insurmountable. And in its evaluation of the Great Egg Harbor route, Ocean Wind completely disregards the consideration most important to the most impacted community, the opinions of the elected officials of Ocean City and their constituents. That is not even listed as a relevant factor. The failure of Ocean Wind to even consider the opinion of the elected officials of Ocean City, the affected community, as the preferred route should be startling to this board when Ocean Wind has other options. The environmental impact statements, which will be required for the project, have not been finalized. BOEM has not issued a final EIS. The National Marine Fisheries Service has not adopted an EIS. And the U.S. Army Corps of Engineers has not adopted the EIS. Any one of these agencies might determine that the environmental impact of the proposed route through Ocean City is unacceptable, in which case the easements would not be reasonably necessary. Waiting until the environmental impacts can be addressed and understood would be prudent. And Ocean City asks the board to defer any decision in this matter until it can review BOEM's EIS and the response thereto of the NMFS and the U.S. Army Corps of Engineers. In conclusion, if NJSA 48.3, in conclusion, if NJSA 48:3-871F were ultimately found to be enforceable in this matter, the BPU would be required to find sufficient evidence in the record to support a finding that the easements and consents which Ocean Wind seeks to take from Ocean City without Ocean City's consent are reasonably necessary. The factual issue regarding the impact of the two bridges which Ocean Wind claims to be impediments to the use of the Great Egg Harbor route suggests that the petition should be referred to the Office of Administrative Law at this juncture. In the absence of a cost analysis as to the various alternate routes, the record is fatally deficient. In light of the apparent inconsistencies between what is possible and proposed for Oyster Creek and what is deemed to be impracticable and fatal to the Ocean City situation in Great Egg Harbor, Ocean Wind's presentation is incomplete or not credible. Thank you.
Thank you for your comments. I now invite Rate Counsel to make their statement.
Thank you, President Fiordaliso. Hello to all the commissioners. Good to see everybody. I too actually am glad that this is virtual because I'm actually in Orlando right now, so it makes it a lot easier to argue from Orlando than from Trenton. I am glad that we've stayed focused on what this is about because that's very important. The issue before the board today is whether this easement is reasonably necessary for Ocean Wind to conduct for its line. In order for the BPU to make that finding, it needs evidence before that the easement is reasonably necessary and the line is reasonably necessary. Because if there's no easement, there's no line. If there's no line, there's no need for an easement. So the goal of the BPU here is to find that this is reasonably necessary. Rate Counsel, unfortunately, can't really take a position on that because we have not had the opportunity to fully probe that issue. Rebuttal testimony was filed answering some of our concerns. We were not allowed to ask discovery about that rebuttal testimony. In fact, there was no discovery in this matter. Ocean Wind, we were asked Ocean Wind if they would answer some questions, and they did answer some of our questions, but not all of our questions. And they didn't have to because there was no discovery in this process. Interestingly, Ocean City raises a number of issues that, quite frankly, we would have liked to have resolved if we had known about them through discovery. And I would have, Rate Counsel would have very much liked to have taken a position. And I want to be very clear on this. We are not opposed to offshore wind, and we are not opposed to any of the projects that are going on. Our only issue is that we want to make sure that this line is reasonably necessary. And in order for us to do that, we need to get certain information, which we were unable to obtain during the process of this matter. Also, as far as the costs go, we're being told that cost doesn't matter in this case. Again, we weren't able to probe that issue. I note that PGM is meeting today, and my understanding is the transmission portion of this of this line is going to triple. PGM is going to increase interconnection costs significantly. For that reason, Rate Counsel wanted to probe where the line was interconnecting, whether it made sense that this interconnection made sense, given the costs that'll be involved. We're taking Ocean Wind's word that any costs with this project will be borne by Ocean Wind. Obviously, Rate Counsel is going to be paying very close attention, as I know will the board, to that issue, to hold Ocean Wind to the feet to the fire, and make sure that ratepayers are not being charged anything that they're not supposed to be charged. And we're going to hold Ocean Wind to their word in this case. But again, very disconcerting. There was rebuttal testimony filed. Mr. Eisenstark started off his arguments by thanking the board for allowing the opportunity to provide additional information. Any additional information that was provided today, Rate Council will not be able to probe, nor will the board. And then Ocean City provided significant new information today that Rate Council cannot probe, and nor can the board, because there's no opportunity to do so. The process here was different than any other process, and I understand this is the first case of its type. And so the process was going to be somewhat different. But the lack of ability to probe the petition, to probe the answers that we got from Ocean Wind, and then to probe what Ocean City just said today, makes it extremely difficult for Rate Council to take a position on this issue. And again, I want to emphasize on this issue, because there's been some comments that Rate Council is opposed to offshore wind, and we are not. The issue before the board today is whether this easement is reasonably necessary. And our position at this time is we don't know, because we don't believe there's sufficient evidence in the record for that decision to be made. With that said, that's really all we have to say. We're not going to take a position on Ocean City's factual arguments, or quite frankly, Ocean Wind's factual assertions, because we haven't had the opportunity to probe them, and we don't feel we're qualified to make those type of assertions at this time. Thank you.
Thank you.
I kept it short for you too, President Fiorelisa.
I'm sorry.
I kept it short for you.
Thank you. Appreciate it. I will now invite the parties to make any rebuttal statements, should they wish. First, Ocean Wind, do you want to make any rebuttal?
Yes, President Fiorelisa, I do. Thank you. Let me make, I'm going to respond both first to Ocean City and then briefly to Rate Council's remarks. With respect to Ocean City, I'm going to lodge a formal objection to the statement that Ms. McCrossin appeared to be reading into the record. It's entirely inappropriate at the closing stage of this proceeding. We're at the very last stage here today. This is oral argument of counsel, and the purpose of oral argument of counsel, as we understood it, and it is most often understood, is to sum up the record evidence that has been presented before. The problem is Ocean City has not really participated in this proceeding until today. So for Ocean City to have its city solicitor appear and be reading from a statement, which she is not an expert on any of those issues, she's just an attorney, to attempt to read stuff in the record that someone else has prepared for her, much of which we've never heard before, it is entirely inappropriate. So we can do this by writing afterwards, but we're going to make a formal motion to have the board strike most of what Ms. McCrossin said. She made some arguments that are legal arguments. I think those are fine. But she appeared to be reading factual stuff that was prepared by someone else. She is not a witness. She did not file testimony. And this also goes to Ocean City's complaints about the process that the board has followed here. Ocean City had every right to fully participate in this proceeding. They had the right to file testimony and have sworn testimony of a witness, have a witness testimony considered, exhibits. They chose not to do that. And that's to their own peril. And to appear at the very last stage of this in arguments of counsel and attempt to interject facts that really aren't evidence at all because they're not supported by a witness is entirely inappropriate. And I cannot express that comment in a more strong manner than I just have. It is entirely inappropriate. Secondly, I want to briefly touch on a couple of the factual allegations that Ocean City did make, which were subject of Ocean Wind's rebuttal testimony, and that basically concerns the so-called Great Egg Harbor route. In both Ocean Wind's direct testimony of Pilar Patterson and in her rebuttal testimony, we provided extensive record evidence of why the Great Egg Harbor route was not ultimately pursued. It has much more to do than the fact whether or not the two bridges that it would have to cross under are historic or not. As we've as we've said in our rebuttal testimony, those two bridges still are listed on the Register of Historic Places. Whether they should be or not is a different question, but there are many other reasons why the Great Egg Harbor route was not desirable. I'm not going to sit here and read from our testimony. Our testimony is part of the record, but it's clear that the Great Egg Harbor alternative is not preferable for a host of reasons: environmental reasons, constructability reasons, interference with marine traffic through the inlet. There is a better alternative. The alternative is the one that we've substantiated through our testimony as the preferred route here. The impacts to Ocean City and its residents will be minimal. The line will be underground. Once the construction is completed, you won't see it and you won't hear it. And quite frankly, it will be no different than the underground facilities that are already in Ocean City. I suggest to you that Ocean City's feigned objection to the route that we've selected has nothing to do with the actual onshore route, but it has to do with Ocean City's overall objection to offshore wind. I'll leave it at that. Let me respond briefly to Rate Council's comments. And again, I don't want to get into a back and forth too much here with Mr. Lippman. I respect Mr. Lippman. Rate Council did have an opportunity to fully participate in this process. Rate Council served discovery on the company's direct testimony. We responded to all of the questions that Rate Council asked. Rate Council had the opportunity to file its own testimony of an expert witness, which it did. It raised a number of issues that it felt were important to it. And then Ocean Wind had the opportunity to respond to it. We believe we've adequately addressed all of Rate Council's concerns. And I will note again, Mr. Lippman did refer, and again, this is not evidence, it's just a reference. He referred to something about a PJM meeting and his belief that interconnection costs will go up. I don't know whether that's true. I don't know what the basis for that statement is, but I do know one thing for sure. Whether it's true or not, it has nothing to do with this filing, because this filing isn't about PJM interconnection costs. It's about the onshore cable route from where the project will make landfall to the substation. There are a limited number of places where offshore wind can interconnect to the existing grid in New Jersey. There are very few, and there's going to be not only Ocean Wind 1, but Ocean Wind 2, the Atlantic Shores project that's been approved, and a large number of other projects that will likely be approved in the future. So again, if we're going to stay on what is an issue here, PJM interconnection costs are not an issue here. They may be an issue for PJM and in other contexts, but they are simply not an issue here. Finally, one last point, and I don't mean to speak too long. I just want to respond again to one other issue that Ocean City did raise, and that is the suggestion that the board should wait till the final environmental impact statement is approved by the BOEM. Well, there are a lot of things that have to go on contemporaneously for an offshore wind project to be constructed. There are state permits. The state permitting process is tied in some part to the federal process, but you can't, you have to do everything at the same time in order for this project to be permitted and constructed. We're already 3 years into the process since the board approved the project. The first commercial operation date that is planned is quickly approaching in early 2024. Everything can't wait for everything else to be done first. It has to be done simultaneously. There is no reason and no requirement under New Jersey state law or otherwise for the board to wait for the federal government's environmental impact statement to be finalized in order to act on Ocean Wind's filing here. Thank you very much, President Fiorellis.
Thank you. Rate Council, would you like to make a rebuttal statement?
Do you want me to go first, or we want Ocean City to go first, Mr. President?
Oh, I'm sorry. You're absolutely correct. My bad, as they say. Ocean City, would you like to make a rebuttal statement?
Just briefly, President. Thank you.
Sure.
The points that Ocean City made today were simply an expansion of the points in the letter previously filed prior to the hearing in this matter. Questioning the authority of the board, with all due respect to the board, but questioning the propriety of the statute under which the board is proceeding today. Ocean City also questioned whether the Great Egg Harbor route was the better route. I was not reading a statement prepared by someone else. I was making reference to the draft environmental impact statement prepared by BOEM, which came out very recently, which summarizes Ocean Wind's proposed course of action with respect to the Oyster Creek project in order to explain to the board and highlight the inconsistency in Ocean Wind's approach to these two projects. What is possible for Oyster Creek is impossible in the Great Egg Harbor Bay. I think that's the only thing that Mr. Eisenstark was complaining about. The fact that I was referring to the BOEM draft EIS, which has just recently come out. But I can assure you that all of those facts are taken directly from Ocean Wind's arguments and the public filings that Ocean Wind has made. Otherwise, I would not have had access to them. They're absolutely properly before this board. And in this unusual process that is being conducted under what I'll again call a hastily enacted statute, I submit that the board should give leeway to the city and allow it to present all of the facts that were argued today. This Ocean Wind makes it sound like it is of no moment to take these easements and property consents because no one will see these cables, no one will hear these cables, and no one will smell these cables. No one will know they're there. Ocean City will know they're there. The power of the Ocean City elected officials has been usurped by the state legislature and turned over to the BPU for the benefit of Ocean Wind. This is not a commentary on offshore wind projects. This is a statement and an argument focused entirely on the statute under which the board is pursuing. And Ocean City objects to property rights being taken away from it against its will, particularly when there is another viable alternative, the objections to which have been overcome by the petitioner in another location. Thank you, sir.
Thank you. Now, Rate Counsel, do you wish to make a rebuttal?
Very quickly, Mr. President. Just a couple things. One, I'll agree with some of the things Mr. Eisenstark said, and I also, have a lot of respect for Mr. Eisenstark. But a couple things I just wanted to point out. One, that while Ocean Wind did respond to all questions, some of those responses were objections and refusal to respond, to provide an answer. So we did not get answers to every question we asked. But I agree with him that the issues that Ocean City raises today, they're important issues, and I wish they had been raised earlier, because these are issues that we would have probed and we would have liked to have gotten some more information on, and I think would have made a more robust record before the board, so the board have everything in front of it that it needs to make a finding that's reasonably necessary. And again, I'm not taking a position as to who's right or who's wrong. To me, what's most important is the board has a full record in front of it so they can make a good decision on what is reasonably necessary.
Thank you, Mr. Lippman.
Thank you.
And thank all of the attorneys who have made their presentations and their rebuttals. Do any of my colleagues have any questions or comments they wish to make at this time?
I have a question.
Yes.
Yes. With respect to the discussion on cost, is it the position of council that the only time that the BPU should be interested or explore issues of cost is when the OREC is being determined?
Is that directed to someone specifically, Commissioner?
I think they've all spoken about cost.
Right.
And the cost issue, and you know, in perhaps, you know, Rate Council, you know, as a follow-up to that, may want to distinguish this proceeding from what is traditionally we experience with what is offered in, you know, let's say a municipal land use proceeding for a pipeline or a different type of line, and the information that is garnered for the board to review in those cases.
Yeah, Commissioner Solomon, it's Craig Eisenstark, and let me perhaps go first, and others can go after me if they like. Yeah, I mean, you know, your question was, is the time that the OREC prices are set, is that the only time the board should be concerned with cost? I think that's the primary time the board should be concerned with cost for a qualified offshore wind project, because as I said earlier, and as everyone's aware, these are competitive solicitations. A lot of work goes into the project's submission of its proposed OREC prices. And, you know, there's a lot of analysis, there's a lot of assumptions made about inflation, future costs, you know, and there's a lot of guesswork going in. So I think, you know, not guesswork, but a lot of analytical work going in, that's the basis for that. So yes, that's the primary time, because those OREC prices are set over the life of the project. And there's very limited circumstances where they can be adjusted. And this proceeding doesn't involve one of the circumstances under which the OREC price can be adjusted. Ocean Wind doesn't have the ability to come to the board and say, hey, you know what, we thought it was going to cost us X to build the onshore portion of the cable from landfall to the substation. It turns out it's going to cost us twice as much. The project doesn't have the ability to do that. That means the project, if that happens, the project is going to, you know, ultimately earn less on its investment. It's unlike a utility. So it's far different than a utility filing under the other statutory scheme, which is similar in some ways, but different in other ways. And that is NJSA 4055D19, you know, where an electric or gas utility comes to the board and says override municipal zoning authority. In that instance, the board is more properly concerned with costs in that petition, because it's a regulated utility and the utility is going to seek to recover all the costs. Here, Ocean Wind, you know, that's not the way OWIDA was set up, and that's not the way the board did the solicitations, is the best way I can put it. The price was set in 2019, and it really is not going to be adjusted here one way or the other. So that's about the best way I can answer your question. Thank you.
Any other council want to make any comments on the commissioner's question?
Yes, sir. I would like to respond.
Sure.
In the opinion of Ocean City, the cost is absolutely relevant to whether going through Ocean City is reasonably necessary. And going through Ocean City is synonymous with whether those easements are reasonably necessary. To take an extreme hypothetical, if the Great Egg Harbor route or any of the other alternate routes that were identified by Ocean Wind cost less than going through Ocean City, how could the board find that going through Ocean City and taking those easements would be reasonably necessary? There would be another viable alternative route. Therefore, taking the easements could not be reasonably necessary. So, of course, the costs are relevant, even outside of consideration of the setting the price of the ORECs.
So this is Brian, and I know this was partially addressed to me, so I want to respond to what was asked of me. Under municipal land use law, cost is a factor that the board considers when looking at whether something is reasonably necessary. What's important to remember, though, is that cost is not the only factor, and it doesn't mean that you necessarily have to take the cheapest route. If there's a better, or not better, but if I think Mr. Eisenstark actually set the standard earlier, it doesn't have to be the best route, it has to be the reasonable route. But the board does look, pursuant to Supreme Court precedent, at how much the cost was for each of the alternatives, and that is one of the factors that the board considers when looking at whether the route is reasonably necessary. And we do believe the board should have been able to look at that in this case. I know that Mr. Eisenstark adamantly disagrees with me on that, and for that reason, we don't have the costs in front of the board in this case. So I don't know what else to say. The costs are not available, so we can't determine whether they factor in favor or against a finding of reasonably necessary.
Thank you. Anyone else have question, comment?
Thank you, Mr. President. I just have a question. I think Ocean City raised a question about the BOEM's environmental impact statement. And is that too late to consider? I don't know what Greg Eisenstark thinks about that. Is that, I think this all should be part of the decision-making process. Correct?
Commissioner, I think your question may have been addressed to me. I'll try to answer it. The draft environmental impact statement was issued by BOEM just a few days ago. From our perspective, it really has nothing to do with this proceeding. I mean, the board, there's a record in this proceeding that's based on the testimony filed and the petitioner's response to the board's supplemental questions and the board's response to rate counsel's questions. It's not appropriate for the board to consider the record in some other proceeding here. I mean, there are many different issues that BOEM looks at in the draft environmental impact statement. It involves literally dozens of federal environmental laws, which quite frankly have nothing to do with this filing whatsoever. So I'm not sure. But the suggestion, the draft environmental impact statement is a public document. It's publicly posted, and anyone can certainly look at it. But again, the record in BPU proceedings, the record is limited normally to the evidence, the file testimony, the other documentary evidence that's before the board. And I'm not sure it would be appropriate for the board to allow, every public document that may be issued by another state or another federal agency about this project into the record here. The focus, as President Fiordaliso said here at the outset in his opening statements, is very narrow. It's under the specific relief requested under these provisions of OETA. And I think that's what the board should focus on.
Thank you. I have a question for the rate counsel, and my question is that you had said that Mr. Lippman repeatedly said that he didn't have enough information. There was not for him to probe into. And what was the reason? And is that not information not being provided? Was there not enough time to probe into? I'm just curious about that.
The way this process was set up, there was no discovery allowed under the process. We were not permitted to ask discovery. I reached out to Mr. Eisenstark. Mr. Eisenstark agreed to accept our questions and to answer them, but that was really between the two of us. The procedural schedule did not allow for discovery. After the filing of rebuttal testimony there was by the company, normally we would have asked some questions, some follow-up questions in a different type of proceeding, and then the company would answer them and then we would proceed. We didn't have that opportunity here. Once the rebuttal testimony was filed, we moved on to oral argument. So it was a very different process, one that is, quite frankly, we're not used to, and it didn't allow for us to ask the kind of questions we would normally ask.
Okay. Thank you for that. I just have I know my question to Greg Eisenstark, is that I know you're not a utility because Ocean Wind is not a utility, but utilities usually engage in settlement discussions. Was there any type of approach to that, or is just we came for the oral argument?
Yes, Commissioner. I think that question was addressed to me. And, I won't go into any details about any settlement discussions that may have taken place because that wouldn't be appropriate in this context. But I will say that there have been settlement discussions between Ocean Wind and Ocean City. I won't go into details about what they were. I will say that Ocean Wind did make a formal written settlement proposal to Ocean City as part of that process. But, obviously, because we're here today, there has been no settlement. So, and I think we said this in our file petition, Ocean Wind would prefer to reach a voluntary agreement with Ocean City. We would have preferred to have done that years ago. We tried our best. We'd prefer to do it now as we sit here today. But unfortunately, the parties have not been able to reach an agreement, and that's why we're before the board. So.
Thank you.
Does Ocean City want to respond to any of Commissioner Shivakula's questions?
No, thank you.
Okay. Just wanted to give you the opportunity to do so.
Appreciate it.
Are there any other questions or comments? Yes.
I have one more. I guess, rate counsel and the issue that Commissioner Shivakula raised regarding process. As this is a case basically of first impression to some extent, is what you're suggesting that you have concerns about the procedure that we're setting forth for future petitions? Is that what you're raising in your comments? Am I understanding that properly?
Yes, Commissioner. I think going forward, and I know there's another one pending already, and I'm certain there'll be more. I think building discovery into the process would be extremely useful, and even perhaps a discovery conference, some type of ability for rate counsel and the company to respond to rate counsel's questions would be extremely helpful for rate counsel to then formulate some type of position so that we'd have the information in front of us that we would feel comfortable. And frankly, a lot of the issues raised today by Ocean City would have been fleshed out in discovery and not come up today in front of us had we had that process. I hope. I can't make any promises, but I would hope that that would be resolved before we got here.
Okay. Any other questions or comments?
President Fiordaliso?
Yes.
I just have one question for Ms. McCrossin. You mentioned 2 historic bridges. Are they listed on the National Register of Historic Places or the State Register?
Commissioner, I'm not sure if they are or not, but neither of them exists. Both of them have been completely demolished and replaced in the last 20 years. And it's that kind of criteria, or that kind of, I'll call it an excuse for discarding the Great Egg Harbor alternative route, that calls into question the analysis. Isn't Ocean Wind just going through Ocean City because it's economically expedient? Does that economic expedience translate into being reasonably necessary? Or if there is another way that it could be done, addressing all of the environmental challenges that they are evidently able to address elsewhere, why go through Ocean City? It's not reasonably necessary. You can go somewhere else. And that's the basis for Ocean City's response. And if the board were open to an adjournment so that the arguments which council believes were made for the first time today could be presented, I'd be happy to present a copy of the BOEM draft environmental impact statement issued just a few days ago in support of Ocean City's arguments. You know, if we were in court and new evidence came up shortly prior to a hearing, a court would have the ability to delay its decision to consider the additional argument or evidence. And I would ask the board to consider delaying its opinion, its decision, and to allow perhaps limited discovery if Rate Council still has unanswered questions, and to allow Ocean City to substantiate the arguments made based on the draft environmental impact statement.
Thank you.
Thank you. Any other council want to make any comments on that?
Yes, President Fiordaliso, and not to prolong it, but I just want to briefly respond to the last statement that Ms. McCrossan made. This isn't new evidence. The EIS process has been ongoing for years now. There have been public documents filed and available on the BOEM website for years. The problem is Ocean City did not follow the procedures that the board outlined for this process. They had every opportunity to file testimony of a witness raising all of the issues that Ms. McCrossan claimed she just discovered shortly before this oral argument. They didn't do so. Had they done so, Ocean Wind could have addressed them in its rebuttal testimony. So to consider those issues now or to delay this proceeding because Ocean City simply didn't play along and is now attempting to interject new issues at the end, it is unfair to Ocean Wind, and it's unfair to the board and the process that the board has set out. So we oppose the suggestion that there's new evidence. We're not sure because, again, it's a statement read by counsel, you know, at the very end of oral argument, and, you know, we don't know exactly what it is or what it's based on. We don't know whether it's even relevant. So we object to the attempts that Ocean City is apparently making here to prolong this proceeding based on alleged new evidence. It's just completely inappropriate. They had the ability to raise these issues months ago. They failed to do so, and they shouldn't be given the opportunity to prolong this proceeding because of their own inaction.
I'll give Ocean City an opportunity to respond if they'd like.
Thank you, Mr. President. My final point would be that if the commission feels that the lack of discovery in this process has had an impact on the process and has affected the ability of any of the parties, including Rate Council, to opine on the issue at hand, and if that evaluation is going to result in a change in the process in the future, so that when Cape May County is dragged through this process, there will be a discovery opportunity, then there should be a discovery opportunity in this process as well, so that there is fairness to the city of Ocean City, the first municipality to go through this new process.
Thank you. I just would like to, and I'm sure I don't have to our learned council and representatives of the various parties, that the board does not make the laws. The board follows the laws. And those laws are passed by the legislature, and it's then our obligation and duty to follow those laws. And we do that in a very prudent, transparent, and fair way. And I think my colleagues will agree that we make every attempt to be fair in any deliberation that comes before us. And it requires reviewing the testimony that we have received, taking into consideration the oral arguments today, and that's why everything is taken by a court reporter, so that we have an accurate account of what happened today. it's important that everyone understand that. It's important that we try to come to the best equitable solution as possible. Since everyone has been given the opportunity to present their oral arguments and make rebuttal statements, no formal action today, no formal action will be taken today in this matter. All arguments made today and all recorded materials submitted under the docket will be taken into consideration, and the board will take formal action on the petition at a later date to be determined. I want to certainly thank my fellow commissioners, and I also want to thank the representatives of the parties for your testimony, for your rebuttal. And it's always, for me personally, more clarifying to verbally hear the arguments. I think I'm a better verbal learner than, particularly with the Bohm report that you referred to. I believe is only 1,400 pages long, and so I assume everyone has read it from cover to cover, and it's quite a document. But as Mr. Eisenstock indicated, our charge is a very narrow one, and but we take all of this into consideration. And again, I want to thank you, Ocean Wind. I want to thank you, Ocean City and Raid Council, for your participation today. And with that, I will close today's meeting. Thank you so much, and stay safe, everyone.
Thank you.
Thank you, everybody.
Take care.